everyone. Welcome to an ALEC TV live stream. I'm Catherine Mortensen from ALEC Public Affairs, and joining me remotely is Andrew Handel. He's the director of ALEC's Task Force on Education and Workforce Development. And in the upper corner there is David Hodges. He is an attorney with the Institute for Justice. And the Institute for Justice was the organization that represented the clients in a historic case that just came down this week from the Supreme Court on educational choice, or educational freedom is another way we sometimes call it. So we want to talk about this case today. It's Carson v. Makin. It came out of Maine, and what it was is the Supreme Court ruled that it is unconstitutional for the state of Maine to offer taxpayer vouchers for students to attend private schools, but to then exclude any school that teaches religious instruction. And it's a little nuanced about how this ruling came about. So, David, we want to just get right into it with you. What does this ruling mean? And is it only restricted to Maine? Does it affect the rest of the country? And so thank you very much for being with us today.
Sure, and thank you so much for having me. It's a pleasure to be talking with you. So basically, there have been three major educational choice cases over the past 2 decades. The first was Zellman in 2002. The second was Espinoza in 2020. And third is this case, Carson. This case has its origins in the Espinoza case. So in Espinoza, the Montana Supreme Court struck down a scholarship program because it provided options for students to attend religious schools. And the U.S. Supreme Court struck down that ruling because it discriminated on the basis of religious status. So in other words, they were saying it's unconstitutional to deny a benefit to someone simply because they are religious. But in that ruling, the court drew a distinction between discrimination based off of religious status, so who you are, and religious use, the things that you do. And to a lot of people, this was a distinction without a difference. Like, after all, what does it mean to say that it's illegitimate to discriminate against someone because you're Jewish or Christian or whatever, but it's perfectly okay to discriminate against you for keeping kosher or something like that. And so, but even though they had this distinction, when they wrote the opinion, the Chief Justice went out of his way to say, even though we're deciding this case based off of religious status, nothing in this case should suggest that discrimination based off of religious use would be any different. So in other words, same exact standard. Nonetheless, Maine had this program, and at the time they were hearing another IJ case, and they looked at the Espinoza decision, and they said, well, this isn't religious status, which is illegitimate. This is religious use. And they basically completely disregarded what the Supreme Court said and said, religious use is okay, even though religious status is not. What happened in this case is that the Supreme Court basically looked at the Espinoza case, looked at what happened in Carson, and said, you know what we said in Carson, and what we said in Espinoza, it holds true. Religious discrimination, whether it's based on religious status or religious use, is illegitimate. And as a result, the decision by the lower court was reversed and remanded. Practically speaking, this ruling applies to everyone, every state. And so a state may no longer make these sort of like hair-splitting distinctions between religious status discrimination and religious use discrimination.
Andrew,
sorry, go ahead, Kat.
No, Andrew, I just wanted to give you a chance to ask the question.
Yeah, no, I was just going to say, David, from a lot of the opponents of school choice who have been commenting on the case, one of the more common things you keep hearing about is this separation of church and state versus, the actual text of the First Amendment, which doesn't quite say that in the Establishment and Free Exercise clauses. So I was curious if you could just, tell us a little bit about that and, kind of the distinction that the court may have drawn between those ideas.
Sure. Well, this whole separation of church and state, idea in this particular case really got a lot of traction from the dissent from Justice Sotomayor, and it was she was pretty worked up in her dissent. And you know what? Even though this was a 6-3 case, I think it's telling that she was the only person who signed on to this dissent with this, very hyperbolic language about the separation of church and state. I think that her view is incorrect, and her view basically stems from a case a few years ago called Trinity Lutheran, and then from Espinoza. And her basic idea is that separation of church and state requires a rule of law in which, when the government provides public benefits, religious institutions and religious people are basically systematically excluded from it. So in other words, you could have a program like as in Trinity Lutheran, where the government provides grants for playground resurfacing. And in her view, everyone should be allowed to participate in this program, unless you are a church or unless you are some sort of religious institution. To her, that is separation of church and state. I think to most other people, that sounds an awful lot like discrimination. And our view is that the Establishment Clause really refers to, an establishment of religion. So if the state, for instance, issued an appropriation every single year in which they said, we're going to give like $1 million to this religious organization and no other, that would pose an Establishment Clause problem. But where in these cases, these benefits are generally available, they are neutral, anyone can apply it, it can apply to them, that's not an Establishment Clause issue. And instead, it becomes a Free Exercise Clause issue if you were saying everyone can access this unless you are religious.
Okay, thank you so much. Okay, and one of the things I want to get to here is the internet was sort of blowing up this week with people sort of misunderstanding what this ruling means. There were lots of tweets out there that I think probably need to be addressed. And I would love for you and Andrew to sort of go through these, and I'm going to share them on the screen here, of where these tweets are wrong. Because I think a lot of people really don't understand, as you were trying to explain, the separation between church and state, what that's all about, and how this ruling, it does in fact not violate that. But here's one. We are hurtling towards theocracy. I'll let you, David, address that one.
Right. Well, I mean, that's just sort of silly. I mean, a theocracy, as I understand it, is a form of government in which there is, one religion and all other religions are either illegal or treated as second-class citizens. What we have here instead is just a general benefit, and anyone can take part of it. If you're Jewish, Christian, Muslim, Zoroastrian, no religion at all, you are still entitled to this benefit. And it's sort of hard to see how you could have a theocracy in an otherwise secular system where anyone can partake in any sort of benefit whatsoever, or choose not to partake in the benefit, and they can use it at places that are religious, secular, or somewhere in between. So that's just a silly, hyperbolic argument.
All right, let's check this one out. This is from respected legal scholar Jeffrey Toobin. Where is SCOTUS heading? Where is SCOTUS heading? All parents get vouchers and they can send their kids to public or parochial schools. Separation of church and state is a vanishing concept at the Supreme Court.
Yeah, I mean, this is also hyperbole. I mean, this was squarely addressed by Chief Justice Roberts, both in Carson as well as Espinoza, in which he said, states do not need to have school choice programs, but if they do have them, they simply cannot exclude people on the basis of religion. That doesn't mean the public school system is going away. It doesn't mean that there's no separation of church and state. It doesn't mean that that we're going into like a total voucherized system. All it means is that if they do choose to have one of these programs, which they don't have to, they just can't exclude people based on religion.
Okay, and the final tweet. Justice Sonia Sotomayor accuses the 6 right-wing justices of trying to, quote, dismantle the wall of separation between church and state after they strike down a Maine law barring religious schools from receiving taxpayer aid. Retweet if you think we must expand the court. And I think that's the last thing I wanted to focus on. And David, are we seeing more calls to expand or pack the court to expand it beyond the 9 justices?
Yeah, I mean, there are certainly some people who are trying to get that going, and I think that when the court was 5-4 with Justice Kennedy as the swing vote, a lot of critics, a lot of progressive critics of the court were content to just lobby him, one way or another. But then once the court moved a little bit to the right with Justice Gorsuch, and then even more with Kavanaugh and Justice Barrett, I think the strategy shifted from trying to persuade the one swing justice to basically delegitimizing the court, so that any sort of ruling that they issued with which they disagreed, would have a cloud over it. I think it's a very cynical strategy, but I don't think that that the notion that the court would ever be expanded, I think that's one that we should take seriously. But we should take seriously, the campaign against the legitimacy of the Supreme Court.
Andrew, did you have anything you wanted to follow up with?
Yeah, no, I'd love to talk a little bit more about the Boyd amendments in state constitutions and statutes. I think right now 37 different states have language that effectively prohibits public funding for religious institutions, and that's what we call a Boyd amendment. So that's where a lot of these cases are stemming from, is religious schools obviously run by religious institutions, and can public funding be directed there? So I'm curious, what do these decisions by the court in both Espinoza and Carson mean for states that have that language in their constitutions? Do they have to follow this, or does a separate lawsuit have to be filed to address the state constitution? I'd love to get your thoughts on that.
Yeah, it's a great question. Basically, as you stated correctly, there are 37 states that have Boyd amendments. And for the most part, these states, after these rulings, they're Boyd amendments. They're not, they don't get stripped out of the Constitution, out of the state constitutions, but they do effectively get rendered a dead letter, meaning that they're still there, but you cannot apply them to discriminate on the basis of religion. There are a couple of states, for instance, Massachusetts and Michigan, that where their blames are not based on religion, like they simply bar all aid to private schools, and those states are not going to be affected, or are not really going to be affected by either of these rulings, because those are simply about where money can be allocated. They're not based on where money can be allocated depending on whether an institution or person is religious or not. So if people want to do things about that, probably the best way of going about it is to try to get those amendments repealed or have them amended.
Okay, so one of the things I want to get to is the larger issue of the 12 myths concerning educational freedom, school choice. A lot of people have the wrong ideas, as we talked about earlier when we looked at those tweets. You wrote a piece for the Institute for Justice not too long ago, and I want to put that up and share it with people. Just give me a second and I'll share my screen, because I think it's worth going through and talking about some of the things that people just don't understand about the educational choice or education freedom movement that's happening in the country right now. What would you say are some of the top myths?
Sure. I mean, the one that we hear most often is that educational choice programs drain resources and funding from an already underfunded public school system. But the reality is that the overwhelming majority of choice programs don't cause a negative fiscal impact on public schools or taxpayers. And in the year since the first choice program was passed, public school spending has skyrocketed on an inflation-adjusted per-student basis, while the learning gains have essentially remained the same. And so what that means is that more funds over time, even on an inflation-adjusted basis, have not translated into improvement in public schools. And we see examples of this all the time. Like, for instance, during the 8 years of the Obama administration, they had this program where they were going to give billions of dollars to what were, I think, like the 1,000 worst performing schools in America. And on like the very last day of the administration, the Department of Education, quietly released this audit of the program where it said that this money, these billions of dollars for these schools, did absolutely nothing in terms of improving grades in those schools.
And Andrew, why do you think that so many parents are moving in the direction of educational freedom and choices and looking for expanded options? I mean, I can tell you as a parent, having gone through COVID, my son was in high school. It was abysmal what happened to so many of our children, and my son included. Is that part of sort of this, what's driving so many parents to look for options beyond our public schools right now?
Yeah, it definitely is. The movement for education freedom has been around for some time, but really in the past 2 years, we've seen a major push and a lot more support building amongst parents at the grassroots level. And, a lot of that is because of the pandemic. I think before COVID hit, we had a routine, right? Most families would, your kid goes to the public school, you drop them off in the morning, you pick them up in the afternoon, you might help with homework at night. And that's it. There was no reason to think that the instruction that was being provided wasn't up to par, and there was no reason not to trust your child's teachers. But that all changed when everybody got thrown onto Zoom, and some parents thought maybe their child wasn't being challenged enough in a virtual environment. Some may not have appreciated the content that was being taught. Things like critical race theory and other controversial content. The key is that every family and every student is unique, and that's why providing as many choices as we can and letting the parents decide what environment is best for their student is going to be the best approach, because for plenty of kids the public school is going to be the best choice, but there's also lots of kids out there who would do much better at a religious school or a non-religious private school or a home school. So it's critical that we have all of these options available.
And one of the things that I want to note is I was doing a little bit of reading on this case was some people had made the point that, so for example, the federal government allows recipients of SNAP money, which is federal aid to help low-income families buy food for themselves and their children. They said you can use SNAP money to buy kosher food. For example, if you are religious, a Jew, you can buy kosher food. And just the fact that you can use taxpayer money to buy food that is part of your religious practice, nobody has ever complained about that. Do you think that that's a similar analogy or a fair comparison, David?
Yeah, absolutely. I mean, I think that is spot on. And I think, for whatever reason, people get a little protective when it comes to K through 12 education. But, look what happens to Pell Grants. We don't live in a world in which a student can receive a Pell Grant and you can go to every single school except for Notre Dame, BYU, Yeshiva, Fordham, and Georgetown. Of course, they can go to those schools because we understand that these are benefits that are for students and they're not benefits for schools or for religious institutions, things like that. And likewise, when it comes to any other kind of benefit, you don't receive money from the government for a welfare payment or something and say, oh, you can use this anywhere but the Salvation Army, or you can't tie this to your church or whatever. So I think that analogy is spot on, and that it's something that should apply in all contexts in which someone receives public funds.
And David, are there any other cases coming up or are points of litigation that need to be settled that IJ is looking at in the area of educational choice and freedom?
At the moment, the horizon is looking pretty good. I mean, this was one of the last places on the frontier. The big cases had to do with the First Amendment, first the Establishment Clause, and now the Free Exercise Clause. And now those issues have largely been settled. What I will say is that for legislators and for policymakers who are looking to pass educational choice legislation, they really ought to contact me and my colleagues at IJ, because there are still a lot of state constitutional provisions that opponents of school choice are going to turn to argue that those programs are unconstitutional under the state constitution as opposed to the federal one. And we still, the vast majority of our litigation is not about the federal constitution, but it's about the state constitutions. So things like home rule amendments or educational clauses, things like that. And it's very important for anyone who's considering an educational choice program to talk to an organization like IJ and ensure that the legislation that they're attempting to pass passes constitutional muster.
And Andrew, is there anything in the way of ALEC model policy that ties in nicely with what we're discussing today?
Yeah. The biggest model policy that we have is our Education Savings Account Act, which offers policymakers, kind of a general template to create, one of these flexible spending account programs to, ultimately put parents in charge. It allows them to spend those education dollars, not just on tuition and fees at private school, but it could be for tutoring services. If you have a child with special needs, it could be for specialized therapies. It could be for extracurriculars at a nearby public school. So it's a great model. We've got that on the books, and we've also got a variety of others. We have our Next Generation Charter School Act, and we've got some homeschooler models in there as well. So there's a really good variety in there, depending on what lawmakers are trying to add to their state.
And before we close, David, I would love to just hear from you a little bit about your background. How did this come to be a passion for you in fighting for this cause? Did you grow up as a student who attended some sort of a charter school, or how did this come to be your passion?
Sure. That's a great question. Thank you for asking. When I was in college, I grew up in a very nice area of New Jersey, but not too far from us was the city of Newark. And when I was in college, a friend of mine was helping run a charter school, and I went over there to go visit him, and I was really just blown away by how different it was from an ordinary public school, and the different care and attention and creativity that the teachers and the administration went into serving the students, having school 6 days a week instead of 5, having this kids there for longer hours and so on, often because it wasn't safe for them to be at home or was just an unstable environment. And it really showed me the power of education as well as alternative educational models. And then, even within a regular, really good public school, you have a lot of kids who are nonconformists or who aren't well served by the model. And, it might work for, 90+% of the kids there. But there are other kids who fall behind, who fall into the wrong crowd, who don't have good friends, whose lives are miserable, or just don't fit in for whatever reason, and they deserve a choice. They don't deserve to spend, their adolescence being, ill-served by the place that they spend most of their time in. And that kind of sums up why I became so passionate about educational choice and educational alternatives.
And Andrew, I'll give you the last opportunity if you have any other questions or anything you want to weigh in on.
Yeah, no, I think it's obviously a great decision out of the Supreme Court in the Carson case, and really resolves that key question. For states with school choice programs, can public funds be directed to religious schools? And as David has laid out so well in this live stream, they've now made it very clear, not once, but not twice, but 3 times, that that it's a clear violation of the First Amendment if states are excluding schools purely based on their religious status. So it's a really good decision, and obviously provides families with more options, and ultimately that's great for everybody.
David, any last comments on this case?
It's a very important case. I encourage everyone to take a look at it. But now that the case has been decided, it's up to us, and it's up to policymakers and lawmakers to recognize that the last barriers to educational choice have been knocked down, and to start enacting legislation so that there could be more choice for students all over our country.
Well, thank you so much, David. We're so grateful for your time and your expertise, and clearly for everything you and your organization are doing to fight for families and giving parents and children more education options. So thank you. And we'll see you next time on another ALEC live stream.